Hi, this is Alan Gassman, and I want to welcome Colleen Flynn to our seminar, our webinar, on when and how to terminate a questionable employee. Employer is probably what the other people are thinking. But anyway, I want to welcome you to the webinar, and I'm going to first speak for about 10 minutes on mostly how not to hire the wrong employee, and then Colleen, who is an excellent employment lawyer with the Johnson, Pope, Rupel, and Burns law firm, is going to talk about terminating employees. We also have a guest with us, Bob Burke, a lawyer in Palm Harbor, one of my heroes and mentors, who is going to chime in towards the end on some of his thoughts on what he's heard. You should be tuned in on your computer, and you should see the advertisement for our next webinar, which is a week from Saturday, November 20, called Cornflakes and Common Estate Planning Mistakes, where I'll talk about common mistakes that people make in their estate planning. So if you're watching the screen, I'm going to try to page forward, and I'm going to ask you, there we go. See here. Okay, common initial hiring criteria. My theme is not to hire the wrong person to begin with. So what we do in our law firm is, first of all, we have them make an appointment, and we question whether they showed up on time. Then, believe it or not, once they show up, our receptionist gives them an application and directs them to an alcove near the reception area, and we time how long it takes them to walk to that alcove. And believe it or not, if they walk slow, it turns out that they will not be a good employee. Third, we time how long it takes them to fill out the forms. If it takes them more than 45 minutes to fill out the forms, they will not be a good employee for us. Fourth, we kind of keep track of what they're doing while they're completing the forms. If they're taking calls and they're texting their friends and they're calling their friends to find out the answers to questions on our questionnaire, they're probably not going to be a very good employee for us. Fourth, of course, we have them take a typing exam, a grammar exam, and sorting tests. And then, if they pass all of these things, somebody at our law firm will interview them. Now, I found out a long time ago that it does no good whatsoever for me to speak with them or even meet them before the hiring decision is made, because I tend to like everybody, and it turns out that likability is not the best criteria for an employee, at least at our law firm. Now, we also will then give a candidate who we would otherwise hire the Omnia Profile Compatibility Test. It costs us $150. It's part of the questionnaire they fill out. And Omnia then gives us a profile which shows us whether this person is aggressive and plays to win, in which event they usually don't make it as a lawyer clerical staff member. Secondly, whether they're cautious and risk-averse, which we want that to be higher. Third, friendliness may or may not count, depending upon what function they occupy in the law firm. Sometimes people who are friendly can't stop talking, and that's a problem if they're working in the billing department or they're trying to type all day. Fourth, whether they're analytical or not. You may want somebody who can really think things through, or you may want somebody who's able to do monotonous work and doesn't want to. Fifth, whether they're flexible and impatient so they can do multitasks, or opposite, whether they're patient and persistent. These two lines, people are either one or the other or a combination of the two. You can't be both. Then whether they're independent and self-managing. And lastly, whether they are afraid to make a mistake. Sometimes if people are afraid to make a mistake, they go too slow. Sometimes if people are afraid to make a mistake, that's exactly what you want. Now this person is somebody we would never hire. And the next page shows you the Omnia psychologist's write-up on the person. Noticing that the Omnia psychologist knows how I work and writes this up showing that she probably would not want to work with me. Then, the next person, this is an ideal candidate for a clerical person in our law firm. They're not real aggressive, they're very cautious, they're friendly enough, they're analytical, they're flexible to put up with changes in situation, they're fairly patient, They don't want to do things on their own. They want to do things as we would like them to do them, and they're very compliant. That's the backstop for mistakes. So you might want to check out Omnia Profiles. The information on that is you would call Carletta Neal, N-E-A-L, at 813-525-7117 and tell her that I said that you're a client of mine and you would get a free profile. Do one on a good employee or a mediocre employee, and you'll be shocked at how well it comes out, how close it comes out to the situation. Now, once we've made the hire, and let me emphasize that that process weeds out most of the people who we would not want to hire. And not hiring the wrong person is a very valuable thing for our law firm. We also run a criminal investigation. All we do is we check on the internet, Pinellas, Hillsborough, and every county where they've lived to look for prior criminal activity. And that's usually where I'll see their picture and their arrest record. Now, when we hire them, they sign a 90-day probationary letter so that if we fire them during the first 90 days, we don't have to pay unemployment compensation, or it doesn't affect our unemployment compensation. And Colleen is nodding yes here. This is something you definitely want to do.
You definitely want to do this, because if you terminate somebody within their 90-day probationary period, it will not be charged against the employer's record. The person may or may not be entitled to benefits based on their history during the last quarters that unemployment looks at, but your employer tax rate will not be implicated or increased if you terminate someone during the 90-day probationary period. So you want to be sure to get it out to them in writing, that they sign off, that they understand that their first 90 days are probationary in nature. And then, in the event that they are terminated within those 90 days, you want to be certain, and we'll talk about this more later, that you fill out the unemployment claim form properly so that your account is not charged for those benefits, because it's been my experience that it's virtually impossible to fix if the initial form from unemployment is not filled out properly by your office staff. And we'll talk about that later.
Okay, and then there's some other things we ask them to sign. They sign our company policy on sexual harassment, that if they see or experience sexual harassment, they must report it to us immediately, whether it's them or someone else. Now, let me go back to that. The next thing we do in our firm is we give them enough training so that they can do one function well for 4 to 6 hours, and then we have them do that function for 4 to 6 hours. Now, in our firm, most of the people here have to know how to type and how to do word processing. So we have fake typing and word processing projects that we give them. We teach them just enough to know how to type a letter and how to print it out and how to get the envelope done, and then we give them 5 to 6 hours of fake work, which they think is real work. And at the end of that day or that second day, we review it very carefully, and we are quite likely to terminate them if they haven't done a good job. Because if they can't do that part of the job, if you can identify a core part of the job, and they can't do that core part of the job the first or second day, then you want to just give them a nice check and I can't say a hug, but you just want to say goodbye as quickly as you can. Now, if and when we have a problem with the employee, we also have a non-compliance notice. And this form is what we use. Somebody sits down with the employee and says, look, here's what happened. We're sorry it happened. We know it was a mistake. We should have warned you better. But, next time, don't go barefoot in the reception area. They fill this out and they sign it. We feel less guilty when we terminate them. I don't know that this has a great legal effect, but it can't hurt. Also, they give us an applicant statement where we can check their information later. That's the release that they sign when they come in. They acknowledge that we can monitor their computer use, and we do in fact monitor their computer use, and there's some very interesting things that come off of that computer when you monitor the use, and we think it's a good thing they know we monitor the use. And then we go to the termination decision. I'm a little bit out of order here, but since I'm on the screen, when you have an employee and you're wondering whether to terminate them, and you have agonized over it, and you are my client, and you finally get around to calling me, 98 out of 100 times, what I'm thinking is, why didn't you already terminate this person? I can tell you from experience that if there's a doubt, there's lots of people who would like to have their job, and you really need to think twice about going through what we call the slow pain of having a problematic employee versus the fast pain of going ahead and terminating that person. I presently have a manager who doesn't mind terminating employees. I cannot do it. I get guilty, I feel bad, I sweat. I can't fire somebody. But I have a manager who likes to fire people. And before her, I had a manager who didn't like to fire people, so I gave her a $200 bonus every time she terminated somebody, because I knew it was an excruciating experience. And Colleen's going to talk a little bit about how you can terminate people, because you don't have to do it face-to-face. You can do it by email. You can do it by phone call. You can be a coward. The main thing is just get them out of your office when it's time to. But when you do terminate somebody, I like the saying, hold your loved ones close and your enemies closer. If you're going to have somebody who's a potential enemy, you want to be very friendly to them. They are not going to admit fault. Colleen's going to tell you, all you really need to tell them is, you're a really, really nice person. I can't tell you how much I like you. I think that you're a better fit somewhere else. And we're going to get more into that. If it's a long-term person and you're going to pay them a lot of money, you might want to pay them over time and tell them, look, I'm going to give you 5 checks a week for the next 5 weeks, but I expect that you're not going to call the other employees and say anything bad about us, and that you're going to return your laptop, and that and that gives them 5 weeks to cool down and to cooperate with you on what you need when you have questions about all those things they were supposed to do that they put in their bottom drawer. Colleen's going to talk about whether you should ask them for a release, or they would release any potential claims against your firm when you terminate them. And when somebody leaves by choice, you definitely want to document that they left by choice, because they may leave by choice and then go down to workers' unemployment and say that they didn't leave by choice. Next, don't hesitate to call in a lawyer or an investigator to interview the other employees when you have someone leave explosively or problematically. The other employees will be very supportive when a lawyer or an investigator sits down with them and says, look, Polly Purebred left last Thursday and she was very upset. And she said some things that we really don't understand, and we want to know, are you aware of anything bad that anyone here did to Polly Purebred? And what happened to Polly Purebred? The employees are going to be very supportive of the employer during that interview. It may go so well that they may put it on tape. On the other hand, a month later, when that employee has left and has become drinking buddies with Polly Purebred, things can be more problematic. So we often have had Colleen or an investigator go in and talk to employees when somebody leaves and the apple cart is being upset. Now, just a couple of whimsical things. The Peter principle. Now, this is where you have good employees and you don't want them to become problematic employees. And you have to remember the Peter principle, which is that everyone rises to their level of incompetence. And you can take a great employee who's doing something at one level, and you can promote them to a level where they will just be awful. You can give them a raise before you find out whether they can handle that better job, and then you can really have a problem. And Professor Peters wrote a beautiful book in 1969, The Peter Principle. It's a great, great work. And his corollary is that lots of businesses in the United States are just full of people who reach their level of incompetency. And the only people getting anything done are the people who haven't been promoted yet. So if you see that in your own organization, you just want to be careful. If you have an employee that you think you might want to promote, you might want to just tell them that you're cross-training. You're thinking about it. Don't give them a raise, just cross-train. Then give it to them for a week. Then tell them how good they did and move them back to a lower position, as opposed to ruining a great employee by making them a mediocre employee. Also, what I call the Marty Schweitzer walk. Marty Schweitzer was a local CPA who we all miss. And he told me, Alan, just walk around your office, say hello to everyone, and ask them what they're doing. You'll be amazed. And I am amazed. I walk by somebody's desk. Hey, Gertrude, what are you doing? Oh, I'm copying the file. Well, Gertrude, that file was already scanned. Why are you copying it? Well, I thought when you hired me 12 years ago, you told me to copy every file. So I've been copying every file for the last 8 years. Well, Gertrude, I bought a scanner 8 years ago. You don't have to copy those files anymore. Oh, great. So walk around your office, say hello to people, and go, hey, what are you doing? Look at their computer screen and whether it's your work or not. I love this little cartoon. The boss says, why aren't you working? And the employee says, I didn't see you coming. All right. Colleen, I'm going to hand it over to you now. I've taken too much of your time.
No.
Thanks for being a good listener. And what do you have to say to us?
Well, I think what Alan said was all good advice, that a lot of these issues can be resolved on the front end. And on the front end, I mean, not only with respect to you investigating your potential employee. And by investigating, I mean, talking with them, giving them the test, calling their references, and really, doing due diligence before you just hire somebody because you're desperate. I assure you your business is not going to shut down because you have a vacancy that's going to remain open for 3 or 4 more days. You will find the right person, and in the end, finding the right person is better and more cost-effective than, hiring somebody because they're the best of the lot, and then a few weeks later realizing we need to start the interviewing process all over again. So I would agree with everything Alan said and just point out that many of these things can be handled on the front end. In essence, I prepared, top 10 things to remember when you're terminating an employee. And well, I see right now up on the screen you've got my background information. I guess a little bit about myself. Like Alan said, I'm a shareholder at Johnson Pope. I practice in the labor and employment group and commercial litigation, work with businesses and individuals and employment-related matters. And, I do a lot of my work is really the day-to-day counseling on clients on their employment and, human resource issues, because many of the clients aren't big enough for a formal HR department or administrator, and so I'm sort of the helper with their own office administrator who may wear many hats and may not have the HR expertise to always know what the laws are when they're faced with questions. So it's a very interesting role that I play these days. So let's see here. Well, we've got, okay, so I guess we're going to start at number 1 here as opposed to number 10. But is there any way if we could fix the PowerPoint to start at 10 as opposed to 1? Can I do that? Let's
sure.
see here.
Flip all the way through there.
Flip to page 34. Okay, let me flip to the end, and then we'll just work backwards here. Get to page 34. We'll start at 10 for everybody.
Wow. Good. Sorry about that.
That's okay. No problem. And then I'll just go backwards. Okay, so now that we are on number 10, I thought we would do somewhat of a top 10 list. When you get to the point where you've decided that it's time to terminate someone or you're contemplating terminating someone, it's important to contemplate what are the reasons. I mean, is it their performance, that they're unable to perform the job duties that they were hired for? Is it that they're just not a good fit, they don't get along well with the other people in the office? Do they have attendance problems, tardiness, calling in sick, constantly needing days off without giving proper notice, not calling in if they're going to be late? I mean, there's a variety of problems. Complaints. Have you received complaints about this person from your clients or your customers, or even your fellow professionals that you work with? I have to tell you that there have been times when I've called other attorneys' offices and I've said, wow, your receptionist is wonderful, or your secretary was great. Or I say, do you know that I was just on hold for 8 minutes and the person didn't even know who you were who answered the phone? So I think, a lot of times we all get complaints from our customers or our fellow professionals that we really need to think about. Is there theft? Are things missing? Are you missing money? I mean, if you're in a doctor's office, are you having problems with drugs disappearing? I mean, what is going on? Internet usage. Alan touched on that earlier, that they have a policy that we will monitor your internet usage. Is your policy that you're not supposed to be on the internet except for business-related work other than, a short period of time? And if I monitor your internet usage and I find that, you're on the internet 4 hours out of the day. Other issues that I thought of that I didn't put on the PowerPoint as I drove over here, I actually thought misrepresentations on applications. Did they misrepresent something that you didn't catch during the interviewing phase that you have later learned is, quite frankly, false? I mean, that is grounds for termination right there. Qualifications, they misrepresent their qualifications. You've got many reasons that you may want to terminate someone. It's important to think through them all, and they're all valid reasons. Here in Florida, we are an at-will employment state, meaning I can terminate you for any reason I want. The caveat is that so long as it does not violate a federally protected right or I'm not discriminating against you. So if Alan and I are, if I hire Alan as any role in my law firm and he is just not getting along with the folks, he cannot work well with them, I just don't really care for working with him, that's a legitimate reason to fire somebody. When you look at what are non-legitimate reasons, we'll go to that in the next slide. But we always want to be certain that we understand the reason for contemplating the termination and making the decision, because based on what the employee does once they become a former employee, it's going to be very important to have consistency in what our explanation is for why they were fired if there is an allegation of wrongdoing on the part of the employer. So it's very important to contemplate, why you're actually firing somebody. And what we'll get to in a moment here is actually documenting those reasons for firing somebody. All right, so let's go back to slide 9, or the 9th reason here.
Just scroll backwards.
All right, let's see. I'm not having
Joke about how many lawyers it takes to run
Right, how many lawyers does it take to run a PowerPoint here?
Bob Burke, are you there? Are you mic'd up?
All right, there we go. Okay. What other issues should be factored into the analysis to make the termination? Once you've started thinking about, well, I want to fire Susie for these reasons, what other issues, if any, should you consider? Well, the biggest issue is that whether the employee has exercised any of their state or federally protected statutory rights. And I understand that most of the employers who are probably listening tonight are smaller and are not covered by many of the statutes that we're going to discuss briefly here. But as I touched on earlier, you cannot terminate somebody for being part of a protected class or having exercised a statutorily protected right. And what does that mean? That means that obviously I think the easy one is that you can't terminate somebody for discriminatory reasons. You don't like somebody because of their gender, their national origin, they're pregnant, things of that nature. We all know those are pretty easy, that those are protected. Under the Americans with Disabilities Act, that's the ADA, you are only covered by the ADA if you have 15 or more employees. So while I am not saying that it is illegal in any way, shape, or form to discriminate against disabled folks, the Americans with Disabilities Act only applies to people with 15 employers with 15 employees or more. The Age Discrimination Act, which is the ADEA, only applies to employers of 20 or more. Title VII, which is what everyone's probably familiar with, which protects gender, national origin, religion, etc., that protects 15 employers with 15 or more. The Florida Civil Rights Act, which mimics the federal act but is a state act, that applies to employers with 15 or more employees. However, you may have local ordinances, depending on what county you're in, that apply. Here in Pinellas County, we have an ordinance that applies to employers with 5 or more employees. However, the federal laws they have a lot of teeth to them, in that you file, charges with the EEOC, lawsuits, et cetera, damages are available. The local ordinance does not have the same damages available as the federal laws do. So keep that in mind. Other laws that you may need to think about are something like the Florida Whistleblower Act. That applies to employers with 10 employees. And when we talk about counting employees, it counts full and part-time employees. So you have to count everybody. You don't just count your full-time people. The Florida Whistleblower Act would apply in a case where an employee has made a complaint to the employer even, not just to law enforcement or an agency, but if an employee complains to you that you are doing something illegal and then you terminate them, they potentially have a Florida whistleblower claim against you. The adverse employment action, they can sue for that. So let's say someone complains to you, they claim that you're filing fraudulent Medicare claims, and that angers you, and so you fire them. Or you demote them from head billing officer to assistant receptionist, and you cut their pay. That is going to be deemed adverse employment action, and they're potentially going to have a complaint against you under the Florida Whistleblower Act because they complained about illegal behavior. Now, I always get the question is, what if they're completely delusional and they're making all these delusional accusations and they become a problematic employee? Well, that's something that you're really going to have to document and be sure that you have enough documentation to prove that they've made outlandish complaints, that they're quote-unquote a troublemaker rather than a whistleblower. So be careful if someone comes to you complaining of illegal behavior by the employer, by yourself basically, and then taking adverse employment action against them. The other thing that needs to be thought of is FMLA, and I understand it probably doesn't apply to anybody here. That's the Family and Medical Leave Act. That applies to employers with 50 or more employees within a 75-mile radius. And that is the law that allows for 12 weeks leave to care for your own serious medical condition or the condition of a family member, or if you have the birth of a child. There have recently been additions to it which provide up to 26 weeks leave to care for an injured service member. So that law is only for 50 employees or more. However, if people have exercised their rights under these laws, you want to be absolutely sure that you're not going to be accused of retaliation. And when I say exercise their rights, what does that mean? For instance, under FMLA, that means have they taken FMLA leave? Have they asked for FMLA leave and you don't want to give it to them, or you're annoyed that they've taken 8 weeks off after they had a baby and so you're going to fire them? Or under the Americans with Disabilities Act, they've asked you for what's deemed to be a reasonable accommodation, and you've denied the accommodation, and now you want to fire them. So you want to be certain when you're contemplating the termination what issues could come up down the road, or what claims could they make against you. I put in here any complaints by the employee, and that really goes into the whistleblower claim, or really any of the claims. Have they complained that they're being sexually harassed by a coworker, and you really like that coworker, you know that coworker would never do it, you can't believe why they would make such ridiculous allegations, and so you say, you know what, I don't want to hear this from you, you're fired. Well, you cannot do that. That's something you need to be careful about. You need to, we could do a whole seminar on this about what to do when someone complains about sexual harassment, but once somebody has complained about something, they are in what I like to call a hyper-protected category. You cannot retaliate against them, because many times it's the retaliation claim that will get you in trouble more than anything else.
That's a good reason for doctors' offices to be very careful about how they bill and about who does their billing work, or whether they use a billing company, because the expense, besides risk of repaying the carriers, is whistleblowers, which we've seen on many occasions.
Sure. I mean, we've all seen in the news these PTAM cases with people, the WellCare case, and trying to get the money back on behalf of the federal government. And so it's just a word of caution there about people. And I'm not saying that people who make all these complaints are always legitimate, but the complaint does not always have to be well-founded or legitimate. Under the statute, it's just that they complained about illegal behavior. So they don't have to win their case by proving that you were doing something illegal. The proof is that they complained about something illegal and that adverse employment action was taken against them. In many instances, I've counseled employers who have said to me, somebody, one of my employees is accusing me of doing X, Y, Z, and I said, well, what have you said in response to them? And what I have come up with is the best way, I think, to handle that when the employee is wrong is to affirmatively tell them, and I even say sometimes in writing, in bullet point format in an email, thank you for your bringing this to our attention. We looked into it, we talked to our CPA, or we talked to whomever, and they've confirmed that our handling of, this tax issue or this other matter is appropriate under, the IRS guidance or something like that. That was just the example that I recently used in a case. So I think that's important to keep in mind when they come complaining about they think you're doing something illegal. Just be careful with that one because, again, Florida whistleblower statute only applies when you have 10 employees. So many of you are going to get closer to that act than any of the others. Once you've analyzed all those issues, what would we do then? Well, the next thing I always tell people is to look at the documentation in the personnel file. And this is really where Alan and I and our presentations are merged very nicely because if you handle getting a lot of the documentation on the front end, it's going to ease your headaches on the back end. And what do I mean by that? The first thing is if you don't have a handbook or company policies that you give out to the new hires and have them sign it before they start working, you need to do that. That needs to have all your policies in there, internet usage, tardiness, calling in sick, grooming, appearance, what are they expected to wear to work, what's your office policy on cell phones, lunch breaks, clocking in and clocking out, filling in timesheets, things of that nature. All of those things need to be in the employee handbook. If you're covered by the Family and Medical Leave Act, the law requires that at the time people are hired, either in the handbook or separately, that they're given a copy of the Family and Medical Leave Act so the employees know their rights. You can get that right off the Department of Labor website. It's Form WH-1420. You don't have to type it up in a pretty version and put it in the handbook, nicely. You can give them that form when they are hired and you have fulfilled your statutory obligations. So at the front end, you really need to be sure that you have the acknowledgement of the handbook and the company policies. That also ties into the 90-day probationary period that Alan was talking about at the outset. Many times the 90-day probationary period is contained in the handbook, as it should be 100% of the time. But I also like it to be specifically stated either in a separate form or on the acknowledgement to the handbook that you give them, and they date the day they start working or the day before, because you want to get them all of this information and get them to acknowledge all of the information before they start working. So you have now met all your obligations under, Family and Medical Leave Act if applicable, under Florida unemployment, that you've given them notice of the probationary period. All of those items need to be signed before they start working. Other things that I would like to see in the personnel file before we make the decision is the performance reviews. What do they say? Are the performance reviews glowing, and then all of a sudden they've complained about something and now you fired them, and then you want to tell me, well, they were terrible at X, Y, and Z? Well, okay, but where is the proof of that? And if the lawsuit comes and their file is now going to come into evidence, there's going to be nothing in that file that shows why, John or Mike were bad at whatever duties were assigned to them. So it's important for employers to do performance reviews and appraisals with their employees, whether it's annually or semi-annually, even more often than that. I encourage everybody to do one within the 90 days because otherwise that 90 days can come or go, and on day 93, if you realize they're not doing a good job and you've blown the 90 days, you're now going to be charged with their benefits. So that's important to do. When you do a performance review, it's also important that the employee signs it, that you've given it to them. they're not acknowledging that they agree with it. You may even want to have a part on there for their comment section, but they are acknowledging that they received it. And that's the important thing, because down the road later, when you have their deposition, and if they say, I never got that, they made that performance review terrible, after I left. I never received that. So I think it's very important to at least have them sign that they received it. They can write in there, I disagree with it, this never happened, these issues weren't my fault, you're a terrible teacher. Whatever they want to write on it is fine, but the important thing is that they acknowledge that they got it. Other things that you should keep in the personnel file if you get complaints by clients. Did you get a written note? I came to your office and your receptionist, Mary, was the rudest receptionist I've ever seen in my 60 years of life. I want that note in Mary's file, because you're going to talk to her and discipline her anyways, but if something happens and then we say, well, one of our clients complained about her, well, what proof are you going to have? How are we even going to remember which client it is? And what if the clients moved away? Are we going to track them down? So that's important. If you have anything from outside sources complaining about your folks, I think it's very important to keep them. Notes on attendance. I find this to be important because this helps to make the claim about attendance in the event that people aren't following proper policies for asking for days off, calling in. Not only, hopefully, if you're keeping good time records, are their time records going to be accurate on when they clocked in and clocked out, but it's important, I think, to document that on, November 11th, Jennifer was supposed to be in the office at 9. She did not call. She breezed in at 9:45 without, a good excuse, and she's therefore being disciplined. And I would have her sign that note, acknowledging that she violated company policy and that, she realized she didn't show up on time. Are they just calling in sick constantly without having leave days? What's their attendance? What are the problems there? Documenting is very important. Discipline notices or corrective actions, whatever you might want to call them, non-compliances, I think what Alan called them, anything you may have that you may write up the employee for. Keep those in the file. Don't get rid of them after a certain period of time unless you've determined that it's your company policy to, erase history after 6 months or a year. I think you should always keep those things. And they're always just good documentation for when the person leaves. And you want to, again, on discipline actions, when you speak with the person about the problem, you want to document it. And I always recommend that the person signs it, that they received it. Again, they're not agreeing with it, but that they did receive it and that you did talk to them. So I think those are the most important things to look at in their file when you're making this decision to terminate them. And having all these papers in the file only protects you in the event that after they're terminated, they bring a claim against you, because you now have documentation in their file about why you fired them. Whether it was performance, complaints, failure to get along, failure to show up on time. You now have all these things in your files so you can prove down the road, if you need to, that you were making a fair decision and not a decision that would violate some law. 7, who should be involved in making the decision to terminate the employee? Well, the first person is the direct supervisor. Should they be involved? Obviously, the direct supervisor has the most information about the person's day-to-day job performance and how they're working out in the office. The direct supervisor's input is going to be vital in the decision-making process and in your gathering of information and really the ultimate decision. So the direct supervisor's input is going to be very important. Practice administrator or office manager for other types of businesses, or the office manager is typically the person, if you don't have a formal HR department or an HR person designated, the office administrator or practice administrator is going to be the person typically who is responsible for personnel issues. And in fact, that may be the person who is the direct supervisor of these folks sometimes. So that person's input is going to be important. I also listed here the managing physician, or really the professional. If you're in a law office, you may have staff, and you may have an office manager, and then you may have the lawyer. All of the direct supervisor and the staff and the direct supervisor of the staff member, as well as let's say the ultimate doctor or the lawyer who that person works for, all the folks are going to have input into the termination and into making the decision to terminate. So I think it's important that you get the information from all parties. Alan, as the lawyer supervising a legal assistant, he has the input into the fact that, well, she's a good legal assistant. Well, maybe the office manager has the information into the fact, well, you know what, she never turns in her timesheets. She is consistently late for showing up for work. I always have to track her down to get XY, get her billing sheets in. So it's important that there is a free exchange of information by the supervisors about the person who is, potentially being terminated. And 6, what everybody hates to talk about, delivering the news. Once there's been a decision that this is the right thing to do, there has to be the delivery of the news, unfortunately. And the issues that we face are the who, what, the when, and the where. Who delivers it? Well, as Alan discussed earlier, he doesn't like to terminate the people. He has a person who doesn't mind. That's fine. You can do it yourself if you're the doctor or the lawyer, or you can have your practice administrator do it. The important thing is not the who that does it, in my opinion, but it's the how and the where and the when and the what. Because the delivery of the message is just that. It's the delivery of the message. The important thing is you're not going to get into an argument with the person you're terminating. You're not going to have a give and take. At this point, you've made the decision to terminate the person. It's done with. The important thing to me is that you do not misrepresent to the person why you are terminating them. Because if there's a problem down the road, the last thing you want to hear in a deposition is, well, isn't it true that when you fired them, you told them the reason you were firing them is X? And when they applied for unemployment benefits, and now when they filed this lawsuit against you, you're telling me that the reason is Y. So consistency is a big issue here. How? Do you have to do it in person? No. Alan's absolutely right. You don't have to do it in person. If the person has absconded and hasn't showed up for 3 days, you can email them and send a certified letter to their house telling them they don't ever need to return, and you wish them the best in their future endeavors.
Well, you can also send them a very friendly letter to their house saying, Dear Matilda, I didn't want to embarrass you or have a stressful event, and I'm sorry, but it hasn't worked out, and here's a couple weeks severance pay, and the stuff from your desk is in a box, and we'll deliver it to you as soon as we get your employee manual back.
Absolutely.
And, you could do it in a very friendly way and not have to face them.
You don't have to face them. That's absolutely true. Now, the issue that Alan just brought up was a severance pay, and we'll get to this at the end, is that if you are offering severance pay, it's always my advice that you get a release in return. You don't owe them severance pay in the state of Florida unless you have a contract with these folks that mandate severance pay. You do not pay it. And in my opinion, if you are paying severance pay to somebody, you should get a release because that is additional consideration to them, and they should give you a release back. So I think the big issue here is not giving them an incorrect reason when you fire them because you're uncomfortable or you don't want to say something. You just can say, Susie, this is not working out. We are going to terminate you. Best of luck to you in the future. If they're sitting in your office, they cause a big scene. That's always difficult. But you have to just, maintain the line, maintain the decision, stay calm, and do not, go back and forth. Do not bargain with them. I think once you've made the decision, you've made the right decision if it's come this far, and you need to stick with the decision.
And you can hire Colleen or me, and we'll come over and terminate them for you, which we've done before.
Right. And I will tell you one experience that I had many years ago. I was hired to terminate or go to a termination with an office manager, and we were going to fire an employee. The employee walks in the door. She sees me sitting there. I think she knows what's going to happen, and the office manager says, I need to speak with you Mary Jane. And Mary Jane, obviously not her real name, says, "Before you say anything, guess what? I'm pregnant." This is a true story. And the office
would have been better to deliver a note to that person.
Well, the office manager looked at me and I said, "Continue," because the decision had been made to terminate the employee without the knowledge that she was pregnant. Now, had she come in before we terminated, days before this, and she said, "Oh, I'm pregnant," and then we said, "Well, we might have a different analysis." But the analysis had been completed. She was going to be terminated. She walked into the office to be terminated, at which time she told the news. And so the news had no impact. So, the office manager, of course, looked at me like, "Oh, dear." And so we continued. She was terminated, and that was done in the appropriate manner. So just keep in mind, once you've made the decision to handle it appropriately, again, like Alan said, you don't even have to do it face-to-face if you don't want to. There's pros and cons to all of it, but I think the biggest thing, like he said, is you just stay calm. It's not a shouting match. You can do it very friendly. You can be done with it. There's certain circumstances that dictate, forceful removals of certain people from offices, but those are typically few and far between. Most cases, it's not a good fit. They're not doing a good job. We just need to end their employment, and everybody needs to just move on. So for the most part, it should go smoothly. Once you've made the decision, you're sticking with your guns. And if you have a person who's your office administrator who is a seasoned veteran and knows how to handle these terminations, you shouldn't have any problem.
And that's their job, make them do it.
Exactly. And I will tell you, I have a sister-in-law who is the nicest person in the whole world, and she used to be the director of HR for a very large company who went through a very, very large round of layoffs, and she fired so many people, I cannot tell you, and she was excellent at it. And it was partially because she was such a kind person, and as she looked at them and told them, "I'm very sorry, we have to let you go," they felt okay about it. She didn't, misrepresent anything. She didn't say anything that wasn't true, but she did it calmly and professionally, and it worked out fine. She's very good at it. So it's not easy. No one will tell you that it's easy to fire somebody, but you can do it. So what happens once the news is delivered? We've got post-termination return of company property. That's always a big one in this day and age. We're going to fix the PowerPoint so you get the right slide here. Post-termination return of company property, changing the locks and the passwords, security codes, all that kind of good stuff. The first thing to remember when you're once you've terminated somebody is they do need to give you their items back. Keys, do they have keys to the office? You need those keys back. Security system code, you need to change it. Computer passwords, when they're on their way out, you want to be sure, if you can, before they go, that you can get into their computer. Whether that's a policy you establish about what their password is, they have to give you their password, that they can't password protect things. I've had many cases where a situation has gone wrong with an employee and they leave and they don't have, the employer doesn't have the password, and maybe that employee had all the passwords to, their payroll program or how to write checks or their client list or their insurance billing code or something. So you want to be sure that you can get into all of their computer programs, software, anything that they maintain. You need to be able to be sure you can get into that. Do they have a computer? Do they have a laptop? You want that computer back. You want to be sure they're not taking anything with them. Do they have client lists? Do they have documents? What do they have? They need to leave it. They can't take it. Here's an important one. Does the employee have an agreement with restrictive covenants? And this is really going to affect, typically it's your higher level employees, your employees who have access to this confidential information. What restrictive covenants do they have? Do they have non-solicitations? Do they have non-competes? Do they have non-disclosures? Even if your employees don't have a formal non-disclosure, you can make arguments under the law that they are stealing things from you if they're taking a bunch of your documents and, many things that belong to you. That's theft regardless of whether or not you have a non-disclosure, but I always would recommend that, you have a non-disclosure agreement with these folks, that they're not disclosing your company property. The things you've developed, your client list, your customer base, your trade, anything that's trade secrets and protectable, you want to protect because it's yours. Other restrictive covenants that sometimes apply, non-compete agreements, non-solicitations, what do they have and what do we need to enforce? Do you need to write them a letter saying, Dear Joe, enclosed is a copy of the agreement you signed when you started. We remind you that you are bound by your restrictive covenants for the next six months or a year, whatever it says. So keep all those things in mind once you've terminated the person because you need all that stuff, for lack of a better term, back. Okay, so what's your next thing you need to think of? Next thing I always think of is dealing with making the announcements to the coworkers, to clients, etc. Sometimes it's difficult. Sometimes you've got somebody who is really well liked that was either terrible at their job or did something improper that you need to fire. It's important to maintain the party line. Whether you don't want to give any details to your staff, I think that in a lot of instances that's a good thing. But in other instances, that's not possible if you have a small office. But you need to maintain the party line, and you can't have conflict between, let's say, what the ultimate decision by, say, the doctor is and the practice administrator who may have had to carry out that decision. The worst thing you can have is the practice administrator saying, oh, I know, Dr. So-and-so shouldn't have fired her. She was such a sweet lady. You can't have that. Consistency in your office is very important among the management staff. Stop gossip. That's a big one. There's always going to be some talk when people are fired. There's always going to be something. There's going to be somebody whose feelings are hurt. They really liked having lunch with that person. But for the most part, you need to, maintain positive outlook, not talk about it. And if you have employees talking about it, you can just say to them, look, it's unfortunate that she had to be terminated, but we're going to move forward and work with the staff that we have now. So it's important. Also, if clients ask you, that you just say it was unfortunate, but we parted ways, and leave it at that, because you also don't ever want to be deemed of having defamed someone or saying something negative about them. The next thing to keep in mind after somebody is gone is the post-termination benefits. They need to get their final paycheck. Luckily, we don't live in California, so you don't have to cut them their check on the day they're going out the door, but you need to give them their final paycheck within the cycle that you use. So if you close on the 15th, they get their paycheck on the 15th. If you have vacation, accrued but unused vacation or sick leave, etc., and your policy says that they get that paid out when they leave, then you need to pay that out when they leave, and you need to cut that check within the next payroll cycle. Most people here probably may not be covered by COBRA. I believe 20 employees, I believe, that are covered by COBRA, but I would have to look that up. Or continuation coverage may be offered under your policy. If they're entitled to COBRA or continuation coverage, I cannot tell you how important it is that they get the proper notices under the law. If they don't get the proper notices and they can't elect in the time period and they lose benefits, you are on the hook. So whether you do it yourself or your insurance company does it or your agent does it or your payroll company does it, you need to be sure that if these people are owed COBRA or continuation coverage notice, that they are given that within the time parameters set forth by law. So that's very important. So what's going to come next? The lovely unemployment claim. And as everybody probably knows, you're going to get the form in the mail that says, Mary Jane has filed for unemployment. Please tell me a little bit about the situation. What days did she work there? What were the reasons for it? The first thing that you need to be cognizant of is checking off the correct boxes. And I know this sounds so silly, but probably 6 or 8 months ago, I had a client who had a person handling all the unemployment claims who did not understand what the boxes meant, and she was checking off the wrong boxes for these people. And it was impacting them greatly because a bunch of folks who should not have been charged to their tax rate were charged to their tax rate, and it was not able to be undone because the appeal period had lapsed by the time I figured out what was going on with unemployment. So when you get the form, please read it carefully and check off the appropriate boxes. The form asks you, was the first person terminated during the 90-day probationary period that you had given them notice of? If that's the case, that's the box to check. Were they terminated because they just weren't doing a good job? Okay, that's the box you check. Did they commit willful misconduct? And willful misconduct is basically something that they did intentionally to the employer, or that's a willful violation of the employer's conduct, policies, or procedures of which the employee was aware and of which the employer has the right to expect that they will follow. This gets into all your documentation about the disciplinary actions. If obviously you're going to have a policy, you can't come to work drunk. If somebody comes to work drunk, that's a violation of your policy, and I would argue that that's willful misconduct. You need to document it, obviously, when it happened. You need to check off the box for willful misconduct, and you need to take the position that they were terminated for willful misconduct when they showed up for work drunk. Likewise, somebody stealing from you. To me, that's willful misconduct. You check off the box for willful misconduct. You make the argument. If it's just that, they're not doing a good job, they're not really good at the job, well, that's not willful misconduct. So you need to analyze it. But if it is willful misconduct, you need to check off the box and take that position. Because once you don't check off the box, it's going to be very difficult, if not impossible, to undo, because they are then going to be awarded benefits based on your checking off the box that they were either terminated for lack of work or terminated because they weren't doing a good job. They're going to get the benefits, and the appeal, when you try to appeal it later, the person's going to say, well, why did you check off this box? I mean, why are you changing your story now? Did you now talk to your lawyer or do some research online and see that you won't be charged? So what's the problem?
Yeah, we're down to about 4 minutes.
Okay, perfect. And so once you get the initial determination, it'll say whether or not the person is entitled to benefits, and if you disagree, you want to appeal it within the time frame that's set forth on the notice. So you need to be certain that when you get these notices from unemployment, that you are following them and that you are making sure all your appeals are going in within the time frame that's appropriate. People always ask me, should I appeal this one? Is this one willful misconduct? Well, each one is different, and you want to analyze it. But if it truly is willful misconduct, I would say that you should check off willful misconduct, and you should fight it, because otherwise you are going to have lots of benefits potentially charged to your account that shouldn't be. I think the bigger issue is the 90-day probationary one. I have seen clients that have high turnover. The high turnover is not a problem to your unemployment rate necessarily, as long as you're giving notice that it's within the 90-day probationary period and that you are terminating these people within the 90-day probationary period. And obviously it's a no-brainer. If the person quits, you check off the box that says they voluntarily resigned. And as Alan said at the outset, it's always good to get it in writing from them that they resigned. So that's important. The number one thing, now that we're down to the top 10, the last thing I wanted to touch on is when you get a reference check by subsequent employers, what do you say and who should answer? My policy is that there should be one person that handles the reference checks, and everybody should know that if you get a call and somebody wants a reference, it's directed to either the practice administrator or the doctor or the lawyer or whomever is deemed the person to give the reference checks. And what should the reference check contain? Obviously their name, dates of employment, their title, and really that's it. I mean, if they want other information, I have, you don't want to be the one giving it. You need to have a policy in place for reference checks. That's the information that you give out. And that way, that protects you from any claims of someone saying, well, Mr. Gassman misrepresented, he said all this false stuff about me, and now I can't find a job because he has said these malicious lies that aren't true. So having a policy that only one person does the references and only verifying dates of employment, title, what they did, and that they did in fact work there is just a conservative policy that will protect you. So that's one thing to keep in mind. The last thing I wanted to touch on that Alan brought up that I had not put in my presentation is if you are in fact going to pay somebody severance when you're terminating them, it is, in my experience, the best idea to get a release. You can get a release that releases you from virtually everything except for claims under the Fair Labor Standards Act for overtime claims, and that's a whole different animal. We can have a whole evening on Fair Labor Standards Act claims, but for the most part, you can get a full release for any and all claims that they may have up through the date of termination in exchange for additional money. You can't just get a release as they walk out the door and say, I want you to sign a release. You've got to give them consideration for the release. And with respect to the Fair Labor Standards Act, the only reason you can't get a full release from that is because those claims require court approval of a settlement. However, you can get them to certify that they've been paid for all hours worked, which could be used as evidence later in a case that they may bring against you under the Fair Labor Standards Act. You say, look, you signed this acknowledging that you were paid everything you were owed, you were paid for all your hours worked, so why are you now claiming this? So even though they could still hypothetically sue you, you have now good evidence. So
the flip side of that, Colleen, is when you give them this release, do they think, wow, I better go show this to my brother-in-law, the lawyer, and go see an employment lawyer, and then think of ways that maybe I can get even more money out of them?
Which is always the flip side. But, you know, right now I think while the economy is tough and people are going to have a harder time finding a job, I think you're going to have more people that say, look, I'm going to sign this release. I don't really have any claims against them. I think it's interesting when people do go and have the agreements read, they talk to an employment lawyer, and the employment lawyer, and in fact, they may be helpful. They may say, look, you don't really have any claims against them. What's your claim? You didn't work out well? You think that so-and-so's a jerk? So it can cut both ways. Alan is absolutely right, but you know, if you think that they're entitled to severance and you want to pay it to them, that's obviously your option to not do it, not do the release. But
right. Bob Burke, are you on the line?
Yes, I'm here.
Excellent. Have anything to say?
Well, a lot of information. A couple of comments, if I might. First of all, I realize the webinar is how and when to terminate someone, but the fact of the matter is that 90-some-odd% of all of this is a function of the efforts in hiring what I'll call right people in the first place.
Right.
100% of the time spent in trying to engage an employee is a small price of investment in comparison to the back-end efforts. I mean, they're just horrific on a back-end basis. Point one. Number two is, as stated, we're an at-will state, but there's legal discrimination and there's illegal discrimination. I can't sit there and fire somebody because of certain federal statutory things. We've all heard the phrase race, creed, color, sex, etc. But just because I wear glasses, for example, now that might even go to a disability, but the fact of the matter is because you're tall or short is there are forms of legal discrimination that are different from illegal discrimination. Second point. The third comment goes to all the various records. I've seen on the webinar, and I totally agree with all the comments about keeping all appropriate records, but the fact is that I suspect that 90% of our clients simply don't keep those records correctly as such, and as a result, if they're going to terminate someone, I would much rather have them avoid the concept of cause and simply say that, you know, it's just not working out. That once you involve cause, then you've got to be able to prove the cause. And it's just far, far more easier, if you will, to simply deal with it on a without cause basis. The last comment was that before I chimed in was the concept of severance, and yes, there is no requirement to pay severance. So what you should do is get an appropriate quid pro quo, whether in the form of some form of release agreement or otherwise, there shouldn't be a severance. I know that we talked briefly about wage and hour, which is its own separate comment. The only comment I'd want to make to those listening is that if they're not paying time and a half past 40 hours, no matter what they're calling their staff personnel, they're inviting getting sued, absolutely inviting it. So just those comments.
Those are excellent, Bob. As a matter of fact, you and Colleen in the last 8 minutes have answered every question that came in. And I agree with everything you said, Bob, and it's interesting. You and I handle the matters that don't become problems, and Colleen handles the matters that do become problems. But the real
I'd like to take just a minute to talk about wage and hour for a second. I mean, there are law firms, unfortunately, brethren of ours in Tampa and other places, that shotgun wage and hour litigation in that we call people managers in some capacity or another. Well, the fact of the matter is that you need to be causing your employees to keep appropriate time records. You need to be paying them time and a half past 40 hours. If you're not doing it, you are absolutely inviting a former employee to sue you. Absolutely every single time.
Right, and Bob, I just want to comment too that, and we could have a whole other webinar on this, we could have a day-long seminar on this, is that people think I pay them salary, so I don't have to pay them time and a half.
Oh yeah, how many times have we all heard that?
Right.
You only have one manager.
Right,
Much.
and you
have everybody be a manager.
Exactly. So I absolutely agree with Bob, and when he's talking about these law firms that do this, you drive up and down the street, you see it on TV. Have you not been paid your overtime wages? There's billboards out there. So this is what they do, and the reason they do this is because the law allows them to collect their attorney's fees. So now not only do you have to hire me, you have to pay them their overtime you should have paid them, plus liquidated damages, plus you have to pay their lawyer. So it's an expensive mistake to make. So just keep that in mind. And Bob, to your point, the other issue that I've been seeing a lot lately is the misclassification of people as independent contractors when they should have been classified as employees.
Well, in those that are of a medical profession on this line, anybody that's being somehow classified as an independent contractor that gets their finger pricked with anything, I guarantee you the next day they're claiming that they're an employee from a workers' compensation standpoint.
And the law really favors that. You're absolutely right. Those are excellent points.
And just so everybody, I was at a seminar not too long ago that I learned that under the current presidential administration, they have increased spending for the Department of Labor and the IRS to come investigate all of the classification of independent contractors because they believe that they've left billions of dollars of tax money and payroll taxes that they should have collected on the table but for this misclassification. So the issue is not only the claim by the contractor/employee, but you're going to have the Department of Revenue on you, and you're potentially have the IRS on you for the payroll taxes. And I believe there's also just a straight flat penalty by Florida if you haven't paid workers' comp on somebody who should have been classified as an employee.
Well, Colleen, let me set up a question here. I'm a typical employer who has less than a certain number of employees, and I'd like you to speak to that particular number. And I don't have a handbook. I don't keep records. Yeah, I've got an application for the employee, and maybe I did certain checks. Maybe it was a credit report check, and maybe there's some drug testing, and maybe there's a criminal background. But whatever I did, that it turns out that it's the wrong person, and I don't have any records whatsoever. Well, are there circumstances where I can be so small that realistically those records are really unnecessary or less than necessary? Because in a typical client scenario, in all respect, I've seen all the various forms and the probation forms and this form and that form, and that would be wonderful if I've got a 200-person office with an HR staff, blah, blah, blah. But, I'm a practicing doctor that's got running around like with hours all over the place, and I don't have time to do any of these things.
In my experience, and I'm only going to speak to Pinellas County because that's where I'm sitting at this moment, we've got the local ordinance that does apply if you've got 5 or more employees. The local ordinance does not have the damage remedies in there that the state and federal acts do. So it's really once you get into 15 employees, that's where you're getting covered by the Florida Civil Rights Act as well as most of the federal statutes, except for the Age Discrimination Act, which gets 20. Keep in mind, too, Florida whistleblower is 10 employees. And unemployment comp, you're going to owe that on, regardless of how many employees you have.
Yeah,
So
one employee is wage and hour, one employee is whistleblower, is unemployment. All of those things apply no matter whether it's just me and some other person.
Right. But I'm going to chime in here. I think most small employers don't follow a lot of the legal jargon, but they do the main things that we talked about tonight.
Right.
They hire the right people. They don't hire the wrong people. They terminate the people who aren't going to work out pretty quickly. They're fair to people. And, knock on wood, it's mostly a great experience hiring people and employing people. We have 30 employees. I love them all. It's a great experience. We have 25 years in business, haven't had a significant problem. Not because we followed all these rules, but because we got the right people on board, and if somebody's the wrong person, all the right people come and tell me. I don't even have myself.
The problem is that most of our listeners are like you, Alan, and hopefully myself, in that we're entrepreneurial people. We roll up our sleeves. We work hard. We don't mind working. You're first in the door in the morning. You're last in the door going out at night. You make the coffee. You wash the windows, whatever the scenario is, and you just try to do the right thing. And oftentimes, employment law doesn't care whether you do the right things. And because of that, you get burnt. And people like Colleen are trying to help people like us from getting burnt.
And Bob, I'll absolutely agree with you. Many of the situations that I deal with on a day-to-day basis, the people were trying to be kind to the employer, they were trying to do the right thing, but they just didn't follow, the letter of the law, and now the person's disgruntled and has talked to, one of these advertising lawyers who, they know the law, and they know what's there, what they can use, and so, it seems sometimes unfair to some of the employers who are really trying to do the right thing by these employees.
All right, well, I'm going to have to call time out here, but I really appreciate everyone who's attended. Very much appreciate Colleen Flynn's excellent preparation, and we're going to have Colleen back for another one of these in a few weeks. Bob Burke, always good to hear from you.
Thank you.
Excellent thoughts. Everyone who's listening, we appreciate your participation. We will have copies of this on our website, and we can also forward you a copy of this if you'd like to see it again or forward it to anyone who you like. Thanks a lot, and good night.
Thank you.